Well, hello everyone. I hope you're doing well. I do have my heating pad back here, which I will be putting on because my back is bothering me some. I did go to the doctor today, to my pain specialist, and tomorrow I see another doctor and another one on Friday. It's just like a nonstop type of a thing, but working on getting to the bottom of it. And tonight, I am very happy to say that I have a guest, and it's someone I have so much respect for. Now, back in 2019, when I first started doing the YouTube thing, and when I was trying to unravel the whole multi-level marketing type thing, I came across Doug's name. Doug Brooks is my guest tonight. He is an attorney. He has over 30 years of experience. And it was in my search of trying to put all the pieces together that I came across his name. And at that time, I reached out to Doug. I reached out to Robert Fitzpatrick. I reached out to Dr. William Keep. I just wanted to get to know the people who had been standing up against deceptive businesses for some time, because I wanted to learn more. And so I really look at Doug and the other people mentioned as really mentors, and I really value the work they've done, their profession, and I just want to say thank you, Doug, so much for being here. So without further ado, let me go ahead and bring on the man, the legend, Doug Brooks, my friend, and I guess fellow advocate in terms of businesses not wanting businesses to treat people poorly. So, Doug, thank you for being here and welcome.
Well, thanks so much, Alana. It was really a kind introduction, and I want to say I'm honored to be a colleague of yours, and I think I really appreciate the work that you've been doing, and in particular, the work on passive. The number of I think it's over 250 videos that you've released, and you've been following them for investigating them for over 2 years. It's really a wonderful job, and you and the other creators on YouTube are so important in getting the word out about MLM and these business opportunity scams. It's just in my 30 years of looking at MLM companies, and I've got 40 years of legal experience, but the 30 years of experience with MLM, never seen anything like the work that you guys on social media are doing. So hats off to you.
Oh, well, thank you so much. And so I invited Doug to come on to discuss what happened on Friday, which was the SEC filed a claim against ONPASSIVE, Mufareh, and his wife. And within that, there is securities fraud. And that's really the big daddy of everything. And yes, through their investigation, they did, say pyramid scheme, but that's not really what is really sticking out. And I think you would agree with that, Doug. And so tonight, I would like for you to start us off with, the SEC deciding to look at a company, maybe like, why do they decide to look at a company, and what do they do when they're looking at a company, and where does that lead them, and where do we go from here? And also, there were a bunch of you, and thank you so very much for submitting your questions. And I do want to, and I think you have Pradeep's questions prepared, like one of the first ones you're going to answer. And I do have his YouTube channel scrolling along on the ticker, and I have a link to it in the video description, which I am going to also put into the chat right now. Pradeep is from India, so he has covered ONPASSIVE on his channel, and he wanted to make sure that some questions were addressed because ONPASSIVE is very big in India. So without any more hoopla of me continuing to babble, because I can babble, Doug, let me turn it on over to you and see if you can kind of like set the groundwork for us.
Sure. And for anyone who wants sort of more detailed information about the legal issues I'm going to talk about, I have at least some of the information is on my website that I just launched a few months ago. It's pyramidscheme.law. And I include in there information about how the FTC laws and how the securities laws interact, as well as I'm working on compiling the laws of all the 50 states that deal with MLM. Usually, when we see the government going after a pyramid scheme or a multi-level marketing company, it's the Federal Trade Commission. They are the primary federal agency that deals with consumer protection issues. Actually, the FTC has two broad mandates. They deal with antitrust and they deal with consumer protection. The Securities and Exchange Commission, which is an entirely separate agency, and as the name implies, their primary role is to deal with securities, investment securities like stocks and bonds. But there's some interesting, or at least interesting to me, series of cases that resulted in an overlap of jurisdiction when it comes to multi-level marketing type pyramid schemes. The FTC has jurisdiction over them by virtue of its mandate to protect people from unfair or deceptive acts or practices in trade or commerce. The SEC has jurisdiction over them to the extent that a purchase in a multi-level marketing company is considered to be an investment contract. And investment contract is a term that's been developed through case law over the years, but in essence, it means an investment of money with the expectation of earning a profit based on the efforts of other people. And so the cases that have developed, including a case that I was one of the lawyers on, Webster versus Omnitrition, have resulted in this situation where both the FTC and the SEC can prosecute companies for being pyramid schemes. So that's why we see the SEC involved in a case like this involving ONPASSIVE. And what the complaint that was just filed sets out in very exquisite detail is undoubtedly an investment of money by all of the founders, the participants, or the members of ONPASSIVE, with the expectation of earning a profit. Obviously, that's what ONPASSIVE is promising. And it's based on the efforts of other people. The name ONPASSIVE implies that you're making an investment that will enable you to earn passive income. You won't have to do much, if anything, to make income out of this thing. So the SEC complaint provides a lot of detail, a lot of very intense pleading that explains why what ONPASSIVE has done violates the securities laws. And it violates them both because securities are supposed to be registered. If you're selling securities, you should be registering them. Obviously, ONPASSIVE has not registered any securities with the SEC. And in addition, when you're selling securities, you can't commit fraud, and you've got to disclose material information. And the complaint goes through all of the false statements that Mufareh and ONPASSIVE have made about this supposed opportunity. So that's the background. That's why we see the SEC involved here. Let me go to Pradeep Pasupuleti's questions. First, he asks, how does the involvement of the SEC affect the legal standing and credibility of ONPASSIVE's operations? All right, well, there's two questions in there, legal standing and credibility. As to credibility, that's certainly a value judgment. I would suggest that anyone who's being sued by the SEC, even if, as in this case, there has not yet been a court judgment, you've got to be concerned. The SEC doesn't file a complaint lightly. They have clearly done a substantial investigation here. My guess is that they've been at it for at least a year. And they have gone through the documents, they've interviewed witnesses, they have had multiple lawyers and investigators involved here. This is certainly a matter of serious concern for anyone who has any involvement with this company. As to legal standing, at this point, nothing has changed. The complaint has been filed, but the court has not made any rulings on it. And the SEC has not sought a temporary restraining order as they could have done, as they often do in these situations. But they haven't done it here yet. And I would imagine that they have certainly have a game plan for how they're proceeding. And we're going to just have to watch it unfold as the days, weeks, and months proceed.
Doug, I'm sorry to interrupt you, but can you please explain to the audience what a TRO is, the temporary restraining order, and how that fits in with this?
Yeah, a temporary TRO is a temporary restraining order. Very often when the SEC files a complaint, they also file a request with the judge to issue a temporary restraining order that prevents the defendant from moving their money around, sometimes prevents them from continuing operating in a fraudulent manner. And because the TRO is typically issued without notice to the defendant, it is by definition temporary. And as part of the order, the judge will set a hearing on what's called a preliminary injunction that's generally within 10 days or 2 weeks of the issuance of the order. So the TRO, the purpose of the TRO is to preserve things the way they are, to prevent the defendant from causing more injury and also from transferring funds to avoid what ultimately might be an order of restitution or disgorgement of funds to reimburse the victims. But it's very frequent that that type of order would be sought when the complaint is filed. And it was not sought. Such an order was not sought in this case. We don't know yet why. We don't know yet what the SEC is what their game plan is. But the point of saying all that is that the court has not yet ruled on the validity of the complaint. So yes, in the SEC's opinion, ONPASSIVE is a pyramid scheme and is violating the federal securities laws, but the ultimate determination of whether that's true will be made by the court. Pradeep's next question is, are there any previous cases or legal precedents involving similar MLM schemes that might offer insights into the potential outcomes of this SEC case? And I've came up with a couple of SEC cases involving MLM type pyramid schemes. And just to give you sort of a range of what could happen. The first case is a company called Zhunrize, Zhunrize. This was an MLM scheme that the product was an online store. So you would purchase a membership, and that would give you a website where you could supposedly sell products, and you would recruit people, and they would get websites basically selling the same set of products. And all these websites were essentially identical. And the company trumpeted about how, we don't have a pyramid scheme problem because we're selling retail, all these products through these retail outlets. But the fact of the matter was their main product was the business opportunity. And I think something like 90% of their revenue was the sale of memberships. And they had about 77,000 people invest, and they collected over $100 million. And the SEC stepped in. They filed a complaint on September 22nd, 2014. This is a case where they did seek a TRO, and it was granted, and then there was a preliminary injunction that was granted. And then by December, the parties entered into a settlement. In essence, the founders of Zhunrize agreed to stop their operations. They agreed to disgorge an amount of money that wasn't settled at that time. It was ultimately settled later on in the case. But here's a situation where, approximately 3 months after the case was filed, the defendant is agreeing to stop their company. Now, the case there was a receiver appointed by the court to collect funds and pay out restitution, and that process took several years. But the key events took place in just a couple of months. The other case I want to point out is, which was just recently resolved. It's a case against an MLM called Sabian, Saivian, and a man named Edward Dalius. And this case, the Sabian was their product was a cashback shopping receipt. So in essence, you would send your receipts to the company, and they would somehow they were supposed to use the data, and that somehow they were going to market the data from all these receipts, and that was going to be the source of the return on your investment. And of course, nothing like that was happening. It was basically a Ponzi scheme where the earlier investors were being paid by the membership fees paid by later investors. The SEC filed a case in October of 2018. They sought a TRO when they filed the case. In this case, the court did not grant the TRO. But so the case proceeded, and the defendants filed a motion to dismiss. That was denied in about a year later. And then there were several years of discovery and mediation and efforts to settle. That a trial date was scheduled. I think it was originally going to be September of 2022. But that was continued. And finally, the primary defendants, Sabian and Dalius, settled with the SEC in February of 2023, this year. And then there was another defendant who was a sort of an enabler, a promoter of the company, and the case proceeded against him, and then he settled just, I think, June or July. So there's a case where the resolution took 5 years. So that there is a wide range of possibility when we look at how these cases proceed, and it depends on the willingness of the defendant to defend themselves, the strength of the case, and there are all sorts of factors. But so it's difficult to make a prediction as to what's going to happen here. But that's sort of the range of options.
I have another quick question, if you don't mind, and that is, does a judge determine if ONPASSIVE qualifies as an investment? How is that? How do they figure out, like, if it does or if it does not?
Well, this was a case where the SEC has requested a jury trial as to all issues so triable, and that's sort of magical language for lawyers, because it means there are some issues where the parties are entitled to a jury, and there's some issues where they're not entitled to a jury. And the basic distinction is you get a jury if you're seeking or someone's seeking damages against you. You don't get a jury if someone is seeking what's called an injunction, which is a court order that you do something or you refrain from doing something. In this case, involves both. The SEC is seeking injunctive relief against ONPASSIVE, but they are also seeking an award of damages. So if the case is tried on that basis, it'll be up to the jury to decide whether the SEC is entitled to damages, and it'll be up to the judge to decide whether an injunction should issue. And so you will have a jury deciding the issues of whether ONPASSIVE is a security, but you'll also have a judge making that determination as to whether the SEC is entitled to an injunction. And it may very well happen that before that trial, the judge may be asked to issue a preliminary injunction, and that will be the judge's decision. The judge will have to make a decision that there's sufficient evidence that ONPASSIVE is selling unregistered securities at that stage of the litigation. Pradeep's third question is, are there any legal implications for individuals who were promoting or recruiting for ONPASSIVE? How might they be affected by the SEC's actions? Well, this is a great question. No one in that description has been sued in the complaint that was just filed, but that could certainly happen in the future. It's fairly common, whether it's the FTC or the SEC, for the agency to not only go after the company, but to go after the big promoters of the company. So if I were someone who had been promoting ONPASSIVE, I would probably want to hire a lawyer just to see what my risks are in this situation.
So, Doug, that would be like the people who like do the daily updates, have weekly shows, nightly shows, and who are continuing to speak about OnPassive and what it's going to do in the future when the products come out, and it being a viable option for what they always say, apples, because they don't want to use money. They think if they use apples instead of saying money, that that's somehow going to shield them. So would that apply to those people that are doing things like that and coming out here regularly and speaking about OnPassive?
Well, it definitely could. Whether it will happen like that, there's a lot of discretion that the SEC has in that situation. They have to make a determination as to how important were those people, how critical were they in people's decisions to spend money on the scheme. How helpful were they to help OnPassive perpetrate its fraudulent scheme? So there's a lot of determinations that have to be made. Whether those people that you described fit into that category, I couldn't say. But if I were one of them, I would be at least concerned about that risk.
So if they were promoting it, because there used to be like friends and family, and there used to be like when they still had founder positions open, if they were promoting it openly, should they be concerned?
Yeah, I would say so. Yeah. Like I say, it's a judgment call. We've seen in the recent indictments of Donald Trump. You see in the federal case a fairly simple action, where Trump is the only defendant, and then in the Georgia indictment that just came down, I think there's 18 other co-defendants. So there you have two different prosecutors, two different systems, making two different decisions as to how wide and deep they want to go with respect to people who are assisting in a fraudulent scheme. Pradeep's fourth question is, looking ahead, what do you anticipate will be the key developments or milestones in this legal case, and how might they impact the MLM industry as a whole? Again, that's two great questions. The first one about key developments in the case, I think I've covered a bit of that. I'd say the next thing I would look for is, will the SEC seek any kind of preliminary relief, an asset freeze, or an order that OnPassive stop operations, something like that, while the case proceeds, or are they just going to go ahead with just based on this complaint? And I'd also anticipate, are they going to widen their field in terms of other defendants, as we've just talked about? And I wonder if there's a possibility of a criminal action here. That could happen. This right now is a civil case, so the only risk for the defendants is having to cough up some money or be ordered to refrain from continuing the business, or things like that. But there's in a case like this, there at least is the possibility of a criminal action. We don't know that.
If it were to become a criminal action, what might the charges be?
They could be basically the same charges, but on a criminal basis, or based on the same facts. Typically, in a pyramid scheme case, the Department of Justice, which handles criminal prosecutions, they use the mail fraud statute or the wire fraud statute. These days, typically the wire fraud statute, because these schemes really can't get accomplished without the use of electronic transmission. I have advocated that the DOJ should use the RICO statute to go after MLM companies, but to date, as far as I know, they haven't done that. But I think RICO, which is the Racketeer Influence and Corrupt Organization statute, I think that was tailor-made for a company, situations like an MLM style pyramid scheme fraud. So that's those are the primary statutes that the government could rely on in a criminal case. The other part of Pradeep's question is, how might this impact the MLM industry as a whole? Again, that's tough to say. I mean, every time the government goes after an MLM company, hopefully there's some impact on people's interest in this business. Often, I mean, to those of us who've been looking at it for a long time, it seems like once someone's involved, they really don't want to hear anything, any negative thoughts. They just want to follow the dream, and it's really difficult to shake them from proceeding with this opportunity. But it should certainly for companies who are involved in this area, it should always give them pause as to how they want to proceed. I mean, ONPASSIVE is a fairly extreme example of a naked pyramid scheme. It's not a typical MLM. So I think companies that are typical MLMs, they could say, well, I'm not going to worry about what happens to ONPASSIVE. That doesn't apply to me. So it's sort of a non-answer to the question, Pradeep, but that's the best I can do at this point.
I have another question, if you don't mind if I just kind of pop in.
No problem.
I've been watching the chat and want to address these if possible. I don't know if you watched the response video that I sent you of Ash, kind of responding to the SEC, but somebody put in the chat that particular video where Ash is claiming that the SEC is pathetic and they're persecuting ONPASSIVE. Does it make it worse for Ash and ONPASSIVE and Ash's wife?
I think the people at the SEC have fairly thick skin. I don't think it's going to, they're not going to behave differently as a result of that. I think it's sort of foolish behavior on Ash's part. I think this is a case that obviously he should be taking very seriously, and maybe it's just bravado and he's trying to make sure. I mean, one of the risks for a company that's being sued by the government is that people will leave, and people who are on the who have been questioning their involvement, this may be the thing that puts them over the edge and makes them decide that they don't want to stay with it. The thing about ONPASSIVE is that so far the investments have been it's been a one-time thing. You pay your $97 and you're in it, and now you're just waiting for the money tree to start bearing fruit, but you're not you don't have this continuous investment that we see in typical MLMs, where the push is not just to recruit new people, but to keep existing people, keep them buying stuff every month to stay active. And in that situation, if you have a government prosecution and people drop out, that is going to have an immediate impact on your revenue. Ash, as based on my understanding, doesn't have that problem. He's sitting on a big bundle of cash that he collected several years ago, and the SEC has talked about how it's been spent on luxury good items for he and his wife, but he doesn't seem to have the problem of people dropping out and then his revenue going away.
Allegedly, when paid products come out, they are supposed to nearly have enough of credits in the back office because they're considering getting 97 credits to be the same as a refund. Ash has said that he's refunding their $97, but it's actually 97 credits to be able to buy OnPassive products, and that whatever is in the back office, that amount will nearly be enough for 1 month. Not quite. And he's thinking about giving them a free month, but they would be paying these in 3-month increments. This is my understanding. And then third month, they would have to pay for it. So that is something in terms of having an ongoing monthly expense would be coming if this moves forward and there are paid products out there.
Yeah. Yeah, that sounds like a fantasy to me, but it's, if that really happens, I wouldn't pay a penny for one of those credits, but that's just me. Let me, I don't, Alana, did that answer your question, or am I being too?
Yep. No, you did. Thank you.
Yeah. Let me move on to, there's another set of questions that you sent me. The first one is it significant that the SEC has filed a civil complaint and asked for a jury trial instead of a hearing before an administrative law judge? That's a fairly sophisticated question, and without getting too far into the weeds, the SEC has by statute, has the option of either going, if they want to sue someone, they can go directly to federal court, or they can file a case with an administrative law judge and proceed on an administrative basis to get an order of an injunction or an order of restitution. And then the result of that case, the defendant could appeal to a federal court, but the main part of the case proceeds before an administrative law judge. That whole process is now in doubt because there's a case the Supreme Court just granted certiorari on, and they'll be hearing it in the fall term, the term that begins this October. And there's a possibility that the Supreme Court could say that that whole administrative law judge procedure is unconstitutional. So I suspect, I don't know, but I suspect that one of the reasons the SEC has filed this case in court as opposed to the administrative law procedure is that they may be concerned about this case and about the possibility the Supreme Court, this Supreme Court in particular, could rule against them. But that's really getting into fairly esoteric legal isges. It's not really my area on in terms of Supreme Court. Trying to read the tea leaves as to what the Supreme Court is going to do with that. The next part of this question is, will ONPASSIVE LCs be deposed and or called to testify? We covered that a bit. Yeah, I think it's very possible that many of them will be deposed and asked to testify. I suspect probably many of them have already been interviewed as part of the SEC's investigation. When will the trial date be set, and will the trial be held in Orlando? The court has not issued any scheduling order yet in the case, so we don't know when a trial date will be. I think that'll happen over the next weeks and months. We will see once ONPASSIVE responds to the complaint. One of the things that will have to happen is that the SEC and ONPASSIVE's lawyers will have to get together and work out a schedule for events to come, and then present that to the judge, and then the judge will decide whether to adopt that or issue his own his or her own order on that. But none of that has happened yet. Are others who are promoting ONPASSIVE and may have been paid by ASH also at risk of being charged? I think we've covered that. How are the Mufarehs paying their expensive legal counsel? Will their assets be frozen? Will the SEC ask for a temporary restraining order pending trial? We've talked about the temporary restraining order that has not been sought yet. The question about paying their lawyer, and this also, there's the next question in this set is the person says, I am curious what happens if it turns out that ASH is funding his lawyer with founders' money. Theoretically, it is possible that that money paid to a lawyer could be forfeited if it turns out that that money was part of the ill-gotten gains, and the lawyer should have known or did know that the source of that money was the wrongdoing. It happens. It happens more often in criminal cases. This is a civil case, but I did check the Department of Justice manual, and they do permit seeking forfeiture of attorney's fees in civil actions. I don't know if it will happen here. It's a difficult burden for the government, but it's definitely a possibility. If I were ONPASSIVE's lawyers, I would want to make at least a good faith effort to make sure that the money that I'm taking as my retainer is not money that is potentially going to be subject to a discouragement order by the SEC.
Can you explain what a discouragement order is?
Discouragement is simply if you obtain money through fraud or some unlawful means, the court can require you to cough it back up, and so that discouragement is just giving back money that you took wrongfully. Also, would the SEC have every single detailed paper trail of ASH's spending from when ONPASSIVE first started until now, or is that only done by the IRS? No, the SEC, I don't know how much, they're clearly, based on ASH's statements in the video that Alonda mentioned that he released after the complaint, there has been some communication between his lawyers and the SEC lawyers, and I suspect they've provided at least some documents. The SEC could have demanded documents from the company. And a big part of the SEC's process here would be to develop a paper trail to follow the money from the time it was paid in to, and there are allegations in the complaint that suggest that they've done at least part of this. And they talk about, well, they've named Ash's wife as a what's called a relief defendant, which means she wasn't a participant in the underlying, fraudulent activity, but she did receive some of the money from that was obtained as a result of this, and she is being sued in anticipation of her having to pay back that money. So even if she didn't do any of the fraudulent things, she still would be subject to returning this money. Much the same as way if someone stole a painting and then sold it to someone else, the person who ended up with a painting would have to give it up, even though they're not at fault. It's just the title never transferred to them. Can the SEC seize the assets since the filing states they will just keep using the funds if there is no relief? Yes, the SEC, as I've said with the TRO, they can request the judge for an order, and this could be both part of preliminary relief or it could be part of the final injunction that they receive. They could seek an order that ONPASSIVE and ASH return the money that they've collected. As to when that could happen, it could be as it happened in that Sabian case. It could be 5 years. It just depends on how the litigation goes. It could be a matter of months. We just don't know at this point.
I'm going to bop in again because somebody did ask this question. I believe the answer is going to be yes. They wanted to know if the SEC would reach out to the company prior to filing a lawsuit to ask them questions.
Yes, they would, and it appears that they did. Obviously, we don't know exactly what transpired, but reading between the lines and what Ash's statement that you mentioned, it appears that there were communications between the lawyers. Then this question goes on: do Americans who make videos promoting the scam have to stop before it goes to trial? The answer is no. Unless there's an order, there's no court order at this point. They don't have to stop. It might be wise for them to stop, but they don't have to stop. The question goes on: does Ash have to stop going live to promote the business? The same answer. He can continue to promote that until there's some court order. He can continue to operate the business as he has.
Another quick question. Can there be any additional claims against Ash if he continued to make false claims to people after knowing the SEC was investigating him, his wife, and ONPASSIVE?
There could be. Certainly, they could. If he continues making fraudulent statements, they could amend the complaint and add those statements as part of the claim. The fact that a lawsuit was filed isn't so significant as simply the continuation of making fraudulent claims. I mean, if he makes misstatements about the lawsuit or the implications of the lawsuit or the effect, that could be the basis for additional claims against him. There's a question here. Does the SEC referring to them as a pyramid scheme mean that they are now considered an official pyramid scheme? In other words, can we now say, quote, this is a pyramid scheme, close quote, without having to use protective language? And I assume this is maybe a question from a content creator concerned about liability. And unfortunately, the answer is that again, that a judge has not ruled on, a judge or a jury has not ruled on whether ONPASSIVE is a pyramid scheme or is a security. I would suggest that what you could say is, which is an absolute factual statement, is that the SEC has filed a complaint in which they say ONPASSIVE is a pyramid scheme. That's right out of the complaint, and that's a fair reporting of a public document. So in the SEC's view, ONPASSIVE is a pyramid scheme, and it's selling unregistered securities and committing securities fraud. But a court has not ruled on those allegations.
Takara, who is a regular viewer, just made this statement, which I think is important, that there are a lot of ONPASSIVE members, meaning from other countries, who do not know what the SEC is. And Ash is playing on their ignorance to tell them that it means absolutely nothing, not to worry about it.
Yeah, I get that. The SEC it's the Securities and Exchange Commission. It is an agency of the federal government that was created in the wake of the stock market crash of 1929, and it has been around for close to 100 years. It is the agency that is of the government that is charged with protecting investors in the stock market, the bond market, and other types of investments. It is an agency that has the power to prosecute people who violate the federal securities laws, and those violations can be the subject of both civil actions and criminal actions. And the consequences of violating the security laws are very serious. So this is not a nothing thing. And as I said, I think at the outset, a complaint like this is not filed willy-nilly. This complaint is the end result of a very detailed and thorough investigation by people who know what they're doing, have a lot of experience with securities fraud and investments. So this is definitely a serious step. This is a substantial warning signal to anyone who is involved with this company. This is nothing not to be taken lightly. Okay. What past precedent can we look to in order to gauge how this may go? I've mentioned those two cases to give you a sort of a range of how these cases can turn out. Was the suit filed in federal court in Florida because Ash is a resident there? Yes, I think that's safe to say that I think I suspect that ONPASSIVE operates in most of the 50 states, but Ash is as I understand it, is a resident of Orlando, so case was filed in the Northern District of Florida. If so, does that mean his New York-based attorney, who only has a bar license for New York, going to have stand-in attorney license in Florida, handle all the filings, etc.? Yeah, that's true. That's very standard practice. For instance, I'm a Massachusetts lawyer, but I've had cases all over the country, and where I'm in another state, I do have local counsel who gets me admitted. It's a Latin phrase, pro hac vici, which just means for the purposes of this action. There's nothing unusual about that, and it's not really a serious obstacle to any lawyer who practices in this area. I'm sure Ash's lawyer he comes from a very substantial, well-respected law firm. I'm sure he's had many cases in Florida, so that's really not a problem for them. Another question someone asks: will ONPASSIVE be allowed to continue if they lose? I would think if the case goes all the way to trial, part of the final order will be some sort of order saying that they have to cease operations. And as I was trying to explain earlier, that might happen earlier on in the case if the SEC decides to seek a preliminary injunction. And this often happens with pyramid scheme cases, before the ultimate trial, there is a preliminary order that the company stop operating as a pyramid scheme. And sometimes a receiver is appointed to collect funds or to operate the company. But certainly, if the case goes all the way to trial and the company loses, it would be unusual that they would still, in this type of case, where they'd still be operating.
I have a question that kind of piggybacks off of that, and that is, can ONPASSIVE continue to operate outside of the U.S. where it is outside of the SEC's jurisdiction?
Yes, it's certainly possible. They could, move their operation elsewhere, and once they have no longer any sort of territorial connection with the U.S., and if they stop, if they don't have any victims in the U.S., they could continue operating to the extent that there are already victims in the U.S. I mean, yes, that even if they stopped operating and moved their operations, they're going forward to another country, the SEC would still have jurisdiction to sue them for discouragement, as we were talking about before, in order to recover the money lost by the U.S. victims. The final set of questions that I have is they're from Dave Vaughn. Dave, this first question is, how is this action different from the actions taken by the FTC? And I'd say, in terms of the legal issues that have to get proven, there are some differences. I'm going to sort of punt on this one and say, if you want to look at the difference between the securities laws and the FTC laws as they concern MLM and pyramid schemes, take a look at my website. I have sections on each of those sets of laws, which I try to explain what's involved there. And procedurally, it's actually it would be fairly similar. What would happen, whether it's the SEC or the FTC? There's this issue of whether the agency seeks preliminary relief from the court, and how the case proceeds procedurally would be very similar. But the legal issues are somewhat different because we're dealing with two different sets of laws, one devoted to consumer protection, the other devoted to investments. Then Dave asks, how does the international nature of this fraud impact the relief victims may receive? I don't think the international nature of the fraud has that much of an impact. I think the SEC will be seeking disgorgement of all the money that ONPASSIVE collected. It is right now it's a U.S.-based company, and I believe that in fact I handled this. I dealt with this issue many years ago in a case against Nu Skin Canada. So my class was a class of Canadian people who were involved in Nu Skin, but the judge ruled that we could proceed in federal court on behalf of that group of people. So I think the nature of the relief would be the same. Dave then asks, so what consequences would Ash face if this is successful? And we talked about the disgorgement remedy. So Ash could be required to disgorge all of the money that he collected, even if he's spent it on luxury goods, or if he's paid it out to some of these other promoters. There could definitely be an order that he be required to return everything, and he could also be ordered to not participate in any other MLM. That's very often that's a part of the relief that's granted in these types of cases. So going forward, he may not be able to participate in MLM companies. So that's it's essentially whether it'll be either or both money damages and some constraints on what he can do in the future and what types of businesses he can get involved in.
Does that mean if he is involved with an MLM right now, which last I checked, he is still part of GDI, would he then be required to no longer participate within that MLM?
It could be if the order, most of the final injunctions that I've seen have a blanket order that the person stop participating in any refrain from participating in any type of MLM operation. So if it's for that type of order, would seem to cover that. It's hard to say, and if it were negotiated, if there were a settlement, maybe he could carve out the right to continue in that company or something like that. I don't know, but the normal type of order would prevent him from continuing to be involved in any MLM. And then Dave asks, what can everyday citizens do to increase those consequences to help ensure Ash doesn't pursue this sort of enterprise again in the future, along with his devoted followers who will continue to believe he was wrongly assaulted by a U.S. agency? That's a great question. I think at the beginning of this video, I complimented Alenda and the other social media people who are involved in the anti-MLM movement for getting the word out more effectively than any government agency or anyone else in terms of the risks and the pain caused by these companies. And I just think that the best thing that you can do is to speak out. If you are a victim, uh, speak out, tell your story. Uh, Go ahead and you should complain to the government agencies and to your congressman. Very important to do that, both federal and state. Um, but also, it's very helpful to tell your story. The more people that are out there that are telling their stories, is telling people that you got involved, you thought you'd found the dream job or the dream opportunity, and it turned out to be uh, uh, this terrible situation. Um, you know, the, someone somewhere is going to read that story, and maybe that'll discourage them from getting involved, and then they won't suffer the same consequences. So I think that's one of the one of the things that you should do.
I don't know if you have more questions. If he had more questions, I have a couple. And I also wanted to say, hey, always, Marco, thank you so much for popping on. And Marco said hello to you as well, Doug.
Hey, Marco.
Okay, what about the business being in his wife's name? How does that impact this overall case?
Um, yeah, I wasn't sure that that was the case, but certainly that may be why she was named as a relief defendant, so that they could be sure of getting an effective relief.
Okay, and I have one more question. And the participants in this are called founders. If they had been called anything other than founder, do you think that Ash would have found himself in this same spot with the SEC coming, down?
Yeah, the name that MLM participants, the names that they're used is random. I don't think it has any impact. The thing that matters is the actual structure, whether they're called founders or distributors or independent business operators or any one of the number of names that MLM companies use. It really doesn't matter. What matters is the substance of what is going on, and are people paying money to participate in a pyramid scheme or buying an unregistered security. Um, so there's no significance that I see to using the name founder.
All right, thank you. I think that about wraps up our time, and you were able to answer a whole bunch of questions, which I greatly appreciate. And I know everybody else who has attended and who's watching and will watch the replay. Oh, wait, I think, how do the huge charges to the business described by Ash affect it? I'm not sure if huge changes. I'm not sure if I understand the question, Johnny. And I don't know if you understand that either. Anyway, but I appreciate everything, all your time and your expertise and answering all the questions that people had, because it's very valuable and I think very important so that people can wrap their head around this. I think it'll be very interesting to follow the case and see how it progresses. One question that I do have is in terms of the response, and I don't remember if it was in the claim or if there is a standard amount of time. How long does Ash's and ONPASSIVE's attorney have to be able to respond to the claim that was put forth?
I think the initial time limit is 20 days, but it's very often for that period to get extended. If he certainly when I filed cases and the defense counsel gives me a call, I would always give him another 20 or 30 days to respond. That's very typical.
Okay. Well, Doug, if you'll just hang out for a bit and we can say goodbye privately. And I just want to say thank you to, so that means stay on here when I end the stream, just let's stay here. Um, because you don't know the show with using StreamYard or anything. Anyway, thank you everybody who attended. Thank you to all of my mods. I appreciate you so very much. You did a great job, and I always appreciate you guys and love you so much. And thank you for anybody who was lurking, hanging out, anybody who participated in the chat. I appreciate it. I appreciate all of you, and have a great rest of your evening. And don't forget, you're beautiful, and I love you. Until next time, good night, all.
Good night. Thanks, Yolanda.
Oh, you're welcome.